putting your values on paper. So Mary Kay Furiasse, I might have butchered that, but as the founding attorney, brings over 30 years of practicing law together with her clinical background as a nurse to A to Z health and elder law. She has earned the board certified patient advocate credential in addition to her bachelor's in nursing and a master's in health law. As previous counsel to healthcare providers, she is a passionate healthcare advocate. She believes that everyone has the right to control their own healthcare decisions and that their dignity should never be compromised. Mary Kay presents frequently to local professional and community groups, helping them to understand the unique legal challenges when faced with an illness, making the healthcare process understandable. She lives in the western suburbs and enjoys spending time with her family and friends. So without further ado, Mary Kay, you can take over. Thanks.
Good morning. Thank you, Patrick. And I want to thank Carol, Jennifer, and Gail for having me today. So we're going to talk about today is some trust, wills, and as Patrick said, estate planning during uncertain times, putting your values on paper. We are living in some very unusual and extraordinary times, and with some deep social changes, economic uncertainty, and the worries and health challenges of the COVID-19 public health crisis. Regardless of your age, gender, or whether you have any pre-existing conditions, there is a possibility that anyone can become incapacitated. And what we mean by that is you lack the physical or the intellectual ability to care for yourselves and to manage your own affairs. Whether you become incapacitated due to illness, injury, or age, it's important to plan ahead and to make sure that your health care wishes are communicated to a trusted person that you've authorized previously to make these medical decisions and to make them on your behalf, and someone that you have also appointed to manage your financial affairs. I know you love your family, as we all do, and there's not a thing that you wouldn't do to help them. Talking about estate planning is a difficult, emotional topic, but it's essential for every family. But I also know that what's in our hearts is not generally enough. At any stage of our life, preparing these must-have documents is one of the most profound acts of love you can bestow and do for your family. This paperwork that we do can shield your family from needless heartache, hassle, and expense. The documents will give you and your family not just financial protection, but also peace of mind. Unless you're certain you have an up-to-date will and a wider plan for what should happen, you shouldn't assume that everything will be taken care of. While the answers will vary from person to person, you should talk with your family, your healthcare professional, your attorney, and any agent or attorney in fact that you appoint about your decisions to make one or more advance directives. If they know what healthcare you want, they will find it easier to follow your wishes. If you cancel or change an advance directive in the future, remember to tell these same people about the change or cancellation. Remember, an advance directive offers loved ones and the medical professionals a roadmap for your healthcare. During times of uncertainty, During times of uncertainty, people may wish to create or update important legal documents that organize their assets. From stocking up on canned goods to wearing face masks in public, Americans all over the nation are feeling the impact of the coronavirus on daily life. While it's unpleasant to think about, now is the time to ask yourself, what can I do now in case I do get sick? In the event you become ill or stuck abroad and are unable to travel home, it's important that you designate trusted people to make sure your bills are paid, Your taxes are filed, money is available for your family, and the medical decisions can be made on your behalf. While it's unlikely that you'll become incapacitated and hospitalized because of the coronavirus, even among those who contract it most quickly recover fully. And it's important to prepare for this or similar scenarios, as there are plenty of other situations like injury, accident, old age, or illness that could leave you incapacitated and unable to carry out your normal responsibilities. To ensure that you have the legal framework in place to provide for your loved ones and to make sure your medical wishes are honored and your financial responsibilities taken care of, taking steps to have the following 3 legal documents should be at least at the top of your to-do list. And those are the living will, the healthcare directive, and a financial power of attorney. Although we have several listed, as I said, those are 3 very important. These documents help you prepare for events like the coronavirus, providing relief for your family members by alleviating the uncertainty regarding your healthcare decisions and your financial obligations. No matter how well an estate plan is structured, it's often necessary to have caretakers in place in the form of trustees, executors, or the individuals with power of attorney. These individuals, or in some cases the entities, shall play a major role in implementing the estate plan as per a desired and a pre-planned structure. If you cannot make healthcare decisions for yourself, a healthcare surrogate may be chosen for you. In other words, if we haven't named the people that we want. Under Illinois law, 2 doctors must certify that you cannot make healthcare decisions for yourself before a healthcare surrogate can be appointed. And a healthcare surrogate can be one of the following people, and they're in order of priority. Guardian of our person, our spouse, any adult children, either parent, any adult brother or sister, any adult grandchild or children, a close friend, or guardian of the estate. And while we do have these named providers or these surrogates in a statute, realize that in some instances they're in a class. So it's not that we necessarily have one particular person that's definitely designated. However, while your healthcare surrogate can make most healthcare decisions for you, there are certain decisions that they can't. For example, a healthcare surrogate cannot tell your healthcare professional to withdraw or withhold life-sustaining treatment unless you have a qualifying condition. And as what is usually considered a qualifying condition, we're talking about a terminal condition, an incurable or irreversible injury for which there is no reasonable prospect of cure or recovery, and that death is imminent, and life-sustaining treatment will only prolong the dying process. The also qualifying condition, number 2, is a permanent unconscious. That's a condition that, to a high degree of medical certainty, will last permanently without improvement. There is no thought, purposeful social interaction, or sensory awareness present, and providing life-sustaining treatment would only have minimal medical benefit. Or another, number 3, qualifying conditions, an incurable or irreversible condition, an illness or injury for which there is no reasonable prospect for cure or recovery, that ultimately would cause the patient's death, that imposes severe pain or an inhumane burden on the patient, and for which life-sustaining treatment will have only minimal medical benefit. There are also limitations on the decision-making authority of a healthcare surrogate that relate to mental health treatments. So it's important to avoid the decision-making limitations of a healthcare surrogate. And that's why you would want to consider having one or more of the advanced healthcare directives. Another important part of incapacity planning is creating a financial power of attorney. This is a legal document in which you name a person, called an agent, to handle legal, tax, financial, and other matters if you're unable to do so. Having a power of attorney in place now may be particularly important so that your agent can transact business for you and help you avoid unnecessarily having to go to a bank or other business location. You might review the detailed powers given to the agent to determine if they should be restricted or made more broad. Consider tax and other provisions. The world doesn't just stop just because you fall ill or become incapacitated due to an injury. Just as you would want someone to make decisions and communicate your healthcare wishes on your behalf, if you're unable, you'll also want to select a trusted individual who will be responsible for managing your money and other property. Should you fall ill or otherwise become incapacitated without a financial power of attorney in place, financial accounts may be inaccessible to those who may need them. Bills may not get paid, tax returns may not be filed, and property may not be bought or sold. Instead, a court may have to appoint someone, possibly an individual you would not otherwise have chosen, to act and oversee. A financial power of attorney can provide a person you trust with the authority, without having to go to court, to handle these issues. If you have an existing document, these are some of the things you would want to consider. Are the people you named as agents still the people that you can rely on? Some people name close friends or family who live at a distance. And given these uncertain times, it might be best to have somebody local who can help you address specific matters. The other thing to think about is the document's so old that the banks and others might be concerned about its validity. Remember, we draft these documents so that third parties can rely on them and feel very confident that the people that they're interacting with are the people that represent us appropriately. So does your document say your agent cannot act until you are incapacitated? You might want to change that to a new power that lets your agent act immediately and not contingent on being you disabled, so that your agent can help you today. The restrictions of only being effective when you are disabled might make your form useless in the current environment. The other thing you might want to consider when preparing a new document is consider permitting the agent to communicate decisions via email, electronically signed documents, and perhaps even Skype, FaceTime, and similar services. It's not clear that banks or other providers will accept this, but it might nonetheless be worth considering, especially given our current conditions. You might also hold the banks and other third parties harmless for relying on such electronic communications, because remember, their responsibility is to us, and if we can make them feel comfortable that who they're dealing with is acting on our behalf, it really will make it a lot easier for both parties, and they will be far more accepting. So let's talk about, we just got through talking about the advanced directives, and we were talking a little bit about the healthcare piece. Now we're going to step back and talk again back into the money piece. So we're talking about, wills and trust. And a will is a document in which you name guardians. If you have minor children, you can provide for how your assets can be distributed in the event of your death. Most commonly, when we deal with a will and a trust, we refer to the will as a pour-over will. And what this means is that it pours or transfers assets in your estate into a trust. So ultimately, your trust is the engine, so to speak, or it's the main document that provides for how you want your assets to be distributed. Many people end up unknowingly damage their estates and hurting their heirs because they don't think they have enough stuff to justify an estate plan. I'm here to tell you this myth needs to be debunked. Because as long as you own something, there will be a legal process to determine what to do with it after you die. This process, called probate, is not only long and drawn out, but it also costs money. That money comes from the estate itself, meaning that those precious few assets you wanted to pass on could end up being sold to pay for probate and taxes. Fortunately, working with an estate planning and lawyer ahead of time allows you the opportunity to protect your assets using whatever tools are appropriate for your situation. Now, if you pass away without a will, we refer to this as intestate. I know there's been in the news, probably recently in the past, some very famous people that have passed away in this particular situation. Prince comes to mind as most current. And what happens is you see in those situations, it leaves many questions unanswered about the personal property, the real estate, the finances. If you die without a will, your estate will be divided according to the laws in the state where you live. Again, like in the Healthcare Surrogate Act, if we don't do our documents, there are laws in place, but they're not always what we want. And the resulting transfer of these assets may be very different from what you would have wished. While certain family members will likely receive part of your estate, close friends or charities that you may have wanted to remember will not be included. And if you're a parent of minor children, dying without a will can have significant ramifications, such as a court having to decide who will have to care for your children. Fortunately, working with an estate planning attorney ahead of time allows you the opportunity again to protect your assets. Now let's talk about some of the things that we could do with our will. What's important is you remember only you know the special circumstances of your family members and your heirs. So what a will can do is you can exercise your right to determine which assets will be distributed to whom, as well as to how and to when. It can name your personal representative to serve without bond, thus again saving your estate money. Recommend guardians for your children. Designate the sources from which estate settlement costs are to be paid. We can do some estate tax planning. We can use some marital deduction, applicable credit amounts. We can make provisions for the distribution of property in the event that both spouses die at the same time. Make special bequests to individuals, churches, educational institutions, and charities. We can create testamentary trusts for loved ones to protect them by providing professional asset management. The greatest obstacle that I find sometimes is preventing some people from completing a will. It's not the cost, but it's the uncomfortable feelings associated with death, especially their own. Now, if you have the document, if you have a current will, many people have ignored their documents for so many years, or decades in some cases, that little of what the documents contain is what they presently want. You know, we've heard the adage, one and done. We really shouldn't be using that adage in these particular situations. Once you make a will, many people will want to put it in a safe deposit box or leave a copy with their attorney and forget about it. However, there's many reasons to review and update your will and other estate planning documents. It's important to have these documents in place to ensure that the executor is someone you feel confident naming, and again, that the dispositive scheme is current. Is everything going in the way that you want to whom the people that you wish it to go to? These legal documents are meant to reflect your current life circumstances and wishes, so they should change as your life does. In the estate, in the estate planning world, we refer to these as the 5 Ds. These are significant shifts that can serve as reminders to us to consider updating your documents. So if these types of things happen in your life, it's a good opportunity to review. For example, if your marital status changes, you should revisit the people you have named as your agents to make medical or financial decisions on your behalf, the personal representative of your estate, and the trustee of any trusts. You probably want to reconsider who you have named as the beneficiary to receive the assets controlled by your will. Finally, don't forget to look at the beneficiaries designated on any non-probate assets, such as life insurance policies or retirement accounts. Imagine your surprise from beyond the grave that you mistakenly left significant assets to your ex-spouse. And believe me, it happens. We also recommend that you review your documents at least every 10 years and more often if you're 60 or older. Even if nothing about your family has changed, there may have been changes to relevant laws. Check in with an attorney to assure that your documents still do the jobs you intended. It could make sense to sign an identical document with a new date to refresh it, especially powers of attorney for finances. Banks like to see those fairly current. If a close relative passes away, there are a few reasons you should revisit your estate plan. Perhaps you are in line to receive an inheritance that changes your financial picture and now necessitates different planning. Or maybe the deceased relative was named as one of your fiduciaries, and you now need to select a replacement, either your agent or personal representative, or was a trustee in one of your documents. In decline, if you or your partner experience a notable decline in physical or mental health, you will want to make sure your estate planning documents include planning for potential long-term costs. There are many different strategies as elder law attorneys we can employ to preserve assets within a family. And these strategies range from what we refer to at our office as either proactive planning or crisis planning. Hopefully, we get you in the proactive planning stage. But whatever stage you are in facing, there is likely something we can do to help save money in the long term. The other situation that we should consider is a new diagnosis, whether it be cognitive or physical. This should prompt us for a review of the documents. Although similar to decline, this D may allow for more proactive planning, giving you an early warning that long-term care costs are in your future, or signaling which partner to whom it is prudent to transfer ownership of assets. While legal concerns may take a backseat to medical and emotional ones in the face of a new diagnosis, we do encourage you not to put off visiting a trusted attorney for too long. All the occasions to update an estate plan mean many opportunities to work with an attorney, to make that relationship you have with the elder law or the estate planning attorney a unique one. You will feel more motivated to give your documents the second and third looks life may require if you have found an attorney or an office with which you can build a rapport. Trying to change. I apologize, my computer doesn't want to. Well, we're going to talk about changing your will. For some reason, my presentation doesn't want to move forward.
Mary Kay, this is Jennifer. I'm going to get it up for you, and then I'll just advance for you. Give me a minute.
Thank you. Thank you.
Thanks, Jennifer.
Yeah. So if you have to change your will, consider how you can validly sign the will and whether remote or electronic signing will work. The easiest way of changing a will is simply to make a new will. It's imperative that you revoke the old will, however. And to do this, you simply write a statement in the new will that states you can revoke all wills and codicils that you have previously made. This is sufficient to revoke any previous wills, but it's wise to also destroy any of your previous wills in order to avoid confusion or challenges to your new will. And as I said, this is a very important, yeah, there you go. Next one. Thank you. Trust me, this happens quite often where we have various versions of a will. So as I said, it's very important to, when you do a new document, to make sure that you destroy the previous so there isn't this confusion. The other way to change your will is by adding what is called a codicil. A codicil is like an amendment, or an addition to your will, and you can use it to revoke a part of your will or to add a new provision. To be valid, it must be dated, signed, and witnessed, just like the legal will. Codicils were an efficient way of changing a will before there were computers, and printing was a hassle. But today, codicils should be avoided pretty much because it's just so much easier to do in a will, and it helps alleviate the cost of confusion. So, you know, I mean, in today's society, that's really just a better way to do it. There are certain there is certain property that passes by law to beneficiaries, and we kind of talked about that earlier, despite what your will says, such as retirement accounts, life insurance proceeds, joint bank accounts, payable on death accounts, and stocks that were registered with a transfer on death form. These all pass directly to a specified beneficiaries. So remember, if you change about who the beneficiary should be, change the names using the forms on which you name the original beneficiaries. In other words, you have to go through the process with the particular financial institutions that you have your assets at. You can't do it through the will because it'll have no effect. Living trusts are also not affected by the terms of your will. If you decide to change the terms of your trust and an amendment to the original trust document, then transfer property in and out of the trustee's name accordingly. You do not need to worry about having to revoke a trust and create an original one, like when you're changing a will. So what I'm saying is that, if we do have a trust, a lot of times it's easier to make ongoing changes because we have a document that by just the nature of the way it is, it's a lot easier to make these changes than we do it simply by amendments. Next slide, please. Now there's types of properties that we don't want to include when making a will. And some types of property carry rules that govern what happens after you die. These rules are independent of your will, mostly because the nature of these types of properties is named to name a beneficiary or to avoid probate. Joint tenancy property is one of them. Now, this type of property grants the right of survivorship to your joint tenant automatically by law. Therefore, when you die, your share of the property passes directly to the surviving joint tenant, regardless of what the will says. There are dangers of relying on joint tenancy. You might be thinking, won't my finances be taken care of if my accounts are held jointly with my spouse, my family member? A lot of clients want to put their children on. The main problem with relying on joint ownership is, and there are many, is that usually it only confers limited power. For example, a joint account holder can access funds and pay bills, but in the case of real estate, they will not be able to mortgage or sell a property without the consent of all the other owners. Additionally, by adding a family member to your accounts or real estate titles, you might be saddling them with an unexpected tax bill by triggering gift tax liability. Further, you may leave your assets vulnerable to potential seizure should the joint owner be sued or have other creditors with claims against them. Should that happen, a court could take your property to satisfy the joint owner's death. One of the ways to avoid probate is to set up a living trust. The property included in a living trust avoids the probate, whereas property in your will does not. Additionally, willing property to someone in your will when that property is already delegated to someone by a living trust is inconsistent. So we have to make those two work together if we have a will and a trust. For example, the property in the living trust automatically goes to the beneficiaries and is managed by the trustee. If you want to change this arrangement, you must do it through the trust forms and documents and not through your will. Life insurance is another one that has named beneficiaries. Retirement plan, including money from pension, IRAs, and 401ks. Stocks and bonds held. This is yet another type that automatically goes to your named beneficiary. So what you're going to want to do is talk to the brokerage company if you wish to change the named beneficiary. Proceeds from a payable on death account. This is the form for this account asks you to name your beneficiary. And again, you're going to have to talk to your bank about making those changes and not doing it through a will. Another one, I get this quite, sometimes people want to do this in their will, and they'll want to leave funeral instructions. Usually, settling of the estate and the probate proceedings do not happen until after the funeral. So the funeral arrangements are among the first matters of business after someone dies. Therefore, generally family members may not even notice your funeral wishes stated in your will until after the funeral. So instead of leaving your funeral wishes in your will, talk with your loved ones about what you want. And you can even make a separate document that spells out your wishes for the funeral. And then you can give this document to the executor of your estate. The other thing is we want to avoid using a will to escape estate taxes. I know, although we talked about it, that it can be done in a will. I don't want to get too complicated here because sometimes we do have to do it that way just to follow particular provisions of the law. But a will is still subject to estate taxes. So instead of trying to use a will to avoid the often heavy estate taxes, explore different types of trust that may work in your situation. Estate planning can be very fact specific. So it's important that sometimes, we don't always go by what our friends have told us or what our friends have done. Trust can escape a lot of tax subjection because the property is not passing directly to the beneficiary, rather to the trust account over which the beneficiary does not have complete control. And remember, will doesn't escape probate. A common misconception is that wills do not have to go through probate proceedings. It's not true. We do have to file the will. And if there has to be a probate proceedings, sometimes it can take months. However, having a will does help to speed up the probate process because your loved ones, the lawyers in the court, are left having to divide all of the property for you, but you've already explained how it should be divided and the court will follow your wishes. There are other ways you can avoid probate. One common way is leaving the property again to the trust with the desired recipient, the beneficiary, instead of granting the property directly to that person. You can also put certain other types of conditions on gifts. Usually, these types of conditions are to encourage someone to do or not to do something. For example, when making a will, you could say to Allison if and when she graduates from college, same within a trust distribution. And then you could also say something too is for property. So for example, to Paul, so long as he uses the property as an art studio. But just keep in mind that putting conditions on gifts can be complicated and can complicate things. So think about who will actually enforce these conditions for how long, and does the enforcer get anything like an executor's fee? So again, these things can be done, but it does consider, you do have to take into consideration some additional things to think about. One of the things we want to do is we want to avoid leaving gifts to pets in a will. Animals do not have the legal capacity to own property. What many people do instead, and this is what we advise, is that they leave the pet with someone who they know will provide it with good care. And then you can also leave that person any property or money to help out with the care of the pet. Next slide, please. Now we're going to bounce back into our healthcare directives and talk about them a little bit more in depth. So as you're in the beginning stages of planning out your estate, you will soon encounter the dual notions of advanced directives and living wills. Living wills not to be confused with pour-over wills. You have the right to make decisions about the health care you get now and in the future. An advanced directive is a written statement you prepare that expresses how you want medical decisions made in the future, should you not be able to make them yourself. Federal law requires that you be told of your right to make an advance directive when you are admitted to a healthcare facility, and the Patient's Self-Determination Act requires that certain providers participating in the Medicare and Medicaid programs to furnish their patients with information on advance directives. The information is to be given to the patients upon admission to a facility or when provisions of care begin. Providers covered by this requirement include hospitals, nursing facilities, providers of home health or personal care services, hospice programs, and health maintenance organizations. Illinois law allows you to make 4 types of advance directives: healthcare power of attorney, a living will, a mental health treatment preference declaration, and a do not resuscitate, DNR, or what is more commonly referred to and what we use in Illinois is what's called a POST, P-O-L-S-T, and that refers to, or what those letters stand for, is practitioner orders for life-sustaining treatment. Now, I know this can seem overwhelming, but it doesn't need to be. Putting your healthcare wishes in writing now will save a lot of hassle for family members in the future. And it's a way to document your wishes concerning medical treatments at the end of life. Your advanced healthcare directives are extremely important legal documents, especially in light of the coronavirus. In case of a medical emergency, these documents will ensure that your healthcare wishes are honored. There are, again, 2 important ones: your medical power of attorney and your living will. In your medical power of attorney, you select a trusted individual to be your agent. The individual you choose will be responsible for making critical healthcare decisions for you, such as determining which treatments you may have. That's the person that, if you're not able to, that your healthcare provider is going to turn to and ask the question, what would you or she or he want in this particular situation? In your living will, you can state your wishes. So we're not naming a person. We're stating wishes about the medical treatment you do or don't want to receive, such as artificial hydration or nutrition, if you are in a persistent vegetative state or terminally ill. Now, these two documents, are the ones that we do as attorneys. And they'll not only provide peace of mind to you, but will also alleviate stress for your family, who would otherwise be burdened with potentially having to petition a court to attain the authority to make these difficult decisions during an emotionally trying time. In addition, as we talked about the post, that's something that you will do with your healthcare provider. It's not something that we as attorneys do, but we do want you to be aware of them, and we do discuss them during our consultations. So without these documents, your healthcare wishes may not be honored, and the person you would have chosen to make the decisions on your behalf may be left out of the treatment discussions with your doctors. Next slide, please. There are many reasons to make a living will. One of them is to give guidance to your doctors and healthcare surrogates, to provide clarity and closure to your loved ones, to prevent conflict or disagreement among family members, and to limit the emotional burden on your closest people at the time of your death. But most important is that you remain the captain of your ship with the authority to dictate how you want to live and how you want to die. Considering that the majority of dying people are unconscious, in distress, or otherwise not able to speak, the living will serves as your voice when you may not have one. A living will tells your healthcare professional whether you want death-delaying procedures used, if you have a terminal condition and are unable to state your wishes. Some people are concerned that doctors will not provide medical care if they have a living will. Remember, a living will, unlike a healthcare power of attorney, only applies if you have a terminal condition. And again, it means incurable, irreversible, such that death is imminent, and that the application of any death-delaying procedure serves only to prolong the dying process. It does not prevent routine medical treatment or care for conditions that are not life-threatening. Even if you sign a living will, food and water cannot be withdrawn if it would be the only cause of death. You can use a standard living will form or write your own. You may write specific directions about the death-delaying procedures you do or do not want. It does require that two people witness. There are some restrictions. Your healthcare professional cannot be a witness. And it's your responsibility to tell your healthcare professional if you have one. You can cancel it at any time, either by telling someone or by canceling it in writing. If you have both a healthcare power of attorney and a living will, the agent you name in your power of attorney will make your healthcare decisions unless he or she is unable. What we commonly say is the living will is a piece of paper that gives that person a little bit of direction as to what your wishes would be. Next slide, please. For those of us contemplating what might happen to them during this pandemic, ventilators are a fraught symbol, representing a terrifying lack of personal control as well as the fearsome power of technology. Used for people with respiratory failure, it's a signature consequence of the severe COVID-19. These machines, what they do is they pump oxygen into a patient's body while he or she lies in bed, typically sedated, with a breathing tube snaked down the windpipe known as intubation. For some, this is their greatest fear, being hooked to a machine, helpless with the end of life looming. For others, there's hope that the machine might pull them back from the brink, giving them another shot at life. One of the considerations that may require special attention is whether your document expressly prohibits intubation. For some people who contract COVID-19, intubation may be necessary to survive. You can distinguish the need for intubation in these circumstances from others if you opt out of them. Again, the persistent vegetative state or the terminal illness. But rather than focusing on whether to be treated with a ventilator, discuss what's most important to you. Is it important for you to be independent? Do you want time with your family? Is it important for you to be walking, living as long as possible, and what you consider a good quality of life? This is what will provide the essential context for making decisions, not only just about ventilation, but in general, making decisions for healthcare and end of life. Next slide, please. The healthcare power of attorney lets you, as they say, choose someone. Again, choice to make the healthcare decisions for you in the future if you're no longer able to make them. You're called the principal in the power of attorney form, and the person you choose to make the decisions is called the agent. Your agent would make healthcare decisions for you only when you're no longer able to make them for yourself. As long as you're able to make them for yourself, you'll have the power to do so. You may give your agent specific directions about the healthcare you do or do not want. The agent you choose cannot be your healthcare professional or healthcare provider. You should have someone who is not your agent witness your signing of the power of attorney. The power of your agent to make healthcare decisions on your behalf is broad. Your agent would be required to follow any specific instructions you give regarding care you want provided or withheld. For example, you can say whether you want all life-sustaining treatments provided in all events, whether you're and when you want life-sustaining treatment ended, instructions regarding refusal of certain types of treatments on religious or other personal grounds, and instructions regarding anatomical gifts and disposal of remains. Unless you include time limits, the healthcare power of attorney will continue in effect from the time it is signed until your death. And you can cancel it at any time by telling someone or by canceling it in writing. You can also name a backup agent to act if the first one cannot. For example, if you've named somebody who lives 1,000 miles away, it may be preferable to have somebody closer in light of the current circumstances. And again, if you want to make changes, you want to do so in writing. Next slide, please. So some of the things you want to keep in mind, choosing the right people to fulfill these roles for the medical and financial. Most people immediately turn to a spouse, an adult child, or a parent. However, due to the emotionally and mentally taxing nature of these roles, a close family member is not always the best person for the role. So to help you choose your medical and financial agents, consider the following. Are they able? Aside from the legal requirements, there's many factors to consider in determining an individual's ability to serve in either of these extremely important roles. Are they willing? Don't just assume that the person you choose is willing and able to set aside the time necessary to fulfill their responsibilities. And again, do they live close by? Due to the coronavirus, many people might currently be under a mandatory or recommended stay-at-home order or may not be able to travel to another city or state. Now I want to talk a little bit, next slide please, about HIPAA.
Mary Kay, excuse
Yeah.
me, it's Carol. We have about 5 minutes and we have several questions also.
Okay, so let's just bounce into the questions.
All right, great.
Yeah.
So the first one is Susie Orman has forms to use for trusts and so forth that are state specific. What are your thoughts on those?
One of the things that I find with the pre-printed forms is that there's so many other things that they don't consider, and they're drafted very generically. So in most situations, I don't find them to be detailed enough. Again, one of the things you have to remember is that you do want them to be relied on by third parties. And I have to say some of the forms that I have seen don't always keep up with the current laws. So it's not advisable, in my opinion, to do them because, again, there's so many other things that you might want to consider and, again, wouldn't be included.
Right. So what is it prudent to have 2 executors on the will, such as 2 of our 4 children? And if I have a trust, do I also need a will?
Yes, you absolutely always need a will and a trust if you have a trust. One of the things is that that's why we call it a pour-over will. That will is specifically designed to be a catch-all. A lot of times there are assets or things that we didn't title properly or fund into the trust, and so it ends up sort of like having what we say like not a place to go. It doesn't have a named beneficiary. It's not jointly owned. So unless we have a pour-over will, it has to go through its own probate proceedings and get distributed according to intestate succession. Because what the pour-over will does is it says everything into my trust. So I always say it's kind of like a belt and suspenders, and that will is kind of that bucket to catch anything. Now, if we keep our documents current and we review our beneficiaries from time to time, hopefully that pour-over will never have to be used. Now, as far as executors, you can do co-executors acting independently or together. And you can do that in trusts. So you can do co-trustees doing the same thing. And then you just can name them in order of preference if the other ones can't. The one thing you can't do is you can't name co-agents under powers of attorney for finance or for healthcare.
Okay, and elder law attorney, regular attorney, financial advisor, CPA, etc. Who can help with all documents, or do we really need to meet with all of those separately and have obviously additional costs by paying each one?
I think the good place to start always is with the elder law attorney or the estate planning attorney. I just want to say a little bit about the difference. Estate planning attorneys, their focus is on ultimate distribution of your assets upon your death, which is what elder law attorneys also do. But we have that added expertise that allows us to sort of navigate and help you plan your documents accordingly if we have this period of incapacity, if we have some issues with long-term care planning. So those are the, the Medicaid, the Medicare, those are the added pieces that elder law attorneys bring to the practice. Now, as far as your financial advisor, most elder law attorneys do not financially advise. So obviously you would need that, and also your certified public accountant. So just like anything else, I think it's advisable to have a very professional team that you can bounce your ideas and have a clear understanding of what your goals and desires are. So yes, I would advise, to have all three of those.
Great. How would an automobile titled in your name only transfer to an heir upon death? And would the will dictate that?
In that situation, it would be, you would have to, depending on the amount of assets, because we're talking about probate, because it's an item that doesn't have a place to go. So we're talking about probate. So it's either we're going to have to go through the formal probate procedure. And that's, if we have $100,000 or more, we're going to have to go through probate formally. If we have $100,000 and less, we can go through probate not have to do the formal, but we do it by our small estate affidavit. So we would fill out the small estate affidavit in that situation, bring it to the DMV. If we were in a probate situation, court situation, we have letters of office and we take that to the DMV.
Great. What can be set up if partner one does not want their personal property to go to partner two's family after partner one passes and then partner two dies?
Those are the credit shelter and the Q-tips. So there's definitely trust provisions, trust planning, and that can all be done through creating trust for that. And they're very specific, and they address exactly that fact pattern.
Okay, if you have the latest POA for healthcare, do you still need a living will?
The living will is, as I said, as long as your agent has a clear understanding, the healthcare providers are going to turn to that agent. So the agent, so if someone's asking me, do I, if you have a power of attorney for healthcare, that's who they're going to look to make those decisions for you. The living will in that situation really just adds evidence of what your intention would be.
And then we have a question of if 5 wishes is a good alternative to a living will.
Again, 5 wishes, the Illinois, current Illinois statutory power of attorney for healthcare has somewhat of that incorporated into it. So, and again, it's a much more, remember, when we're doing these documents, we're looking for third parties to rely on them. So if we're in a healthcare situation and we're using an Illinois form that our providers are familiar with, it's going to be to our advantage rather than, the 5 wishes. It's an okay form, but again, it's if you realize or remember what the purpose of doing these documents is for third people to feel comfortable with them.
Okay, we're at 1 minute. Mary Kay's information is in the chat box for you. We thank you, Mary Kay, very much. AZ Health and Elder Law, very trusted partner with Elderwerks, of course. And if we did not get to your question, Mary Kay's email is there, or ours, just send it over. We'll get it answered for you, but she's certainly very helpful and can answer whatever you need. Thank you so much. And we will start again at 11 o'clock. Have a great day, everyone. Thank you, Mary Kay, and thank you for support of Elderwerks.
My pleasure. Thank you.